and Kath will try her best to answer as many of those as possible. And as Kath mentioned at the start, we may get time towards the end to open the microphones as well. So for the time being, please keep your microphones on mute. And as Kath said, you're more than welcome to keep your cameras switched on, but that's your personal preference. So without further ado, I will hand you over to Kath.
Good afternoon, everybody. I'm learning the good afternoon, and I've remembered to press record. So I've got the first two things ticked off my list, which is amazing. I'm still admitting people, and one of the things I don't know, barristers are not very good at technical stuff. I am not entirely sure if I go into share screen whether I will be able to still let people in. So I'll just let people in for a minute while I tell you a little bit about me, and then we'll get into a bit more of a presentation style. Thank you for joining. As Sean said, my name is Kath Brown, and I was a barrister in King's Chambers in Manchester for just short of 15 years. I escaped 6 years ago, and now I should tell you what I do, but I'm very allergic to elevator pitches. I'm not very good at summing up in 2 minutes what I do. But what's relevant, I suppose, is that I've taken everything I learned in that time, and there's a lot there, to use it to coach and train, to milk every last bit of those 80-hour weeks, which were not much fun at the time, but fun in retrospect. So I work with people on confidence, on communication, imposter syndrome, and things like that, as well as helping experts and witnesses know about the court process so that they can do a better job within it, hopefully. Hopefully, you should be able to see a PowerPoint shortly. Do shout up in chat if you can't. I will come back to you from time to time. I won't leave you looking at a slide all day. You can look sometimes at my kitchen, but we will hopefully get there together. So, it takes a little while to move on this, I think, and I'm now going to move on probably to, let me just try that again. I'm going to try and show you a slide which will give you a private quiz you can take part in. Competing with yourself. Seeing if you can guess, I'll do it in this view because it might be a bit easier. Seeing if you can guess why poo emoji, a taxi cab, and a lunchbox might assist you in being better at communication. I'm hoping also to throw in the Beatles, the Teletubbies, and a few other wild cards as we go. If you have just joined us, we asked at the beginning if you could put questions in chat. I'll try to come to them at regular intervals. We are recording it, and we'll try and have time for live questions at the end. Okay. What I've done is structured essentially 10 top tips that barrister hands down to barrister, and structured some more advice of wider application around those. So, as a further spoiler, not only will there be a taxi cab, there will be a piece of advice which suggests to you that you should make sure your audience understand what you're talking about. And I spent 15 years as a barrister thinking everybody knew what we did and what the difference was between us and solicitors. And I know there are a number of learned solicitors on this call. So I'm going to be very careful at how I define the difference. They, in many ways, can be almost identical professions now. So I'll give you the traditional difference. A comparison frequently used to be made between a GP and a consultant, in that solicitors are most similar to primary care providers. You go to them first, and they might be able to just solve your problem from beginning to end. If the solicitors come to a point where they need specialist advice or specialist advocacy, speaking up for people in court, previously, historically, they would tend to instruct a barrister. Can now instruct solicitors with what we call higher rights of audience, solicitors who can appear in any court. I've mentored 2 of those people, one of whom has left the profession, one of whom actually joined my chambers and became a barrister. So there are lots of people who think they're stuck in the wrong job. Successive governments' attempts to fuse the profession have largely failed, but I am talking about tips from the courtroom, so they do apply to all advocates, not just barristers. So I will say that to be fair, and they also apply to anybody who wants to get better at using those communication skills. So tip 1 that we pass down from judge to barrister to junior barrister to pupil is write your closing speech first. And I've paraphrased that as beware the principle. I work as a coach with lots of people. I'll just stop sharing so I can come back and keep an eye on the chat. I work with lots of people who tell me it's the principle. I need to have it out with him. It's not fair. I've been hard done to. And what I frequently tell them is, well, where is that going to get you? Communication largely should have a purpose. This is not advice on how to behave at dinner parties. I'm not suggesting you turn up at dinner parties with planned presentations and particular aims that you want to get through. But if you are going to somebody and asking for more flexible working, then it is a good idea to be very clear at the outset what you want before you have that conversation. And I will just share with you the story, an anonymous story of somebody I coached who had gone through an appraisal which had left her feeling very, very aggrieved. She felt she'd been ganged up on. There were 2 of them and only 1 of her. She was presented with facts, supposedly, that she had been, and I think I'm right in saying that she'd been told she was overly emotional, which sounds like some potentially discriminatory behaviour from the start, doesn't it? But she had been told that, but without evidence. And she was upset, she was pretty cross. She said she wanted to have it out with them. Having it out with somebody, for many people, will cause them stress. A lot of people put off conversations. They don't like confrontation, is something I hear a lot. They would rather keep quiet, wait for the problem to go away. So if you are going to go to the trouble to have a conversation with somebody, to tackle a difficult issue, you want to avoid A, it being pointless, and B, having to do it twice. So what you should do is try and be very clear about what you want. And with that particular client, when we worked through it, she established that what she really wanted was an apology. I do also have a slide somewhere that says beware the forced apology, but for her that was important. The more practical stuff was that she wanted to be assured that that wouldn't happen again, that there would be a different procedure for the appraisals, that notice would be given, that a friend could accompany her, and so on. I don't think she achieved all of those, but she achieved some of them. And she was able to approach that conversation knowing what it was she wanted out of it, knowing when it would be over. If you're going to have a difficult conversation, you want to try and avoid it going round and round in circles. And unless you really know what it is you want, it's quite hard to know when it's finished, either successfully or unsuccessfully. And I'll just pause there to say, I'm going to try and cross-reference these to some different communication scenarios. That tip of knowing what you want is a particularly useful one for anybody who backs away from providing feedback to their employees. What you don't want your feedback to be is a bit whingy and a bit moany, and I'm a bit hacked off and you've annoyed me a bit. You want, rather than having a go at the person, I would suggest you want to have a focus on the behaviour. So you need to ask yourself first why it's hacking you off, and you need to work out what the adjustment is that you're going to require from that other person. It helps, I think, to think about feedback as corrective suggestion, to be able to leave them with a clear plan. And I fall into the very common trap there of thinking about feedback and thinking only about the negative. Positive feedback, you can follow the same method in that rather than saying well done, can you be clear about what they did do well, what you want more of, what you want to see more of, what the company wants more of. Don't have time to go into that massively today, but I do adopt a conflict resolution model when it comes to feedback. There's a really good, if slightly cheesy, book called Nonviolent Communication by Marshall Rosenberg. And it's very focused on helping you work out why you're feeling aggrieved, why you're feeling that a conflict is coming, and then setting about resolving it in a neutral, non-violent, non-aggressive, I'm sure we're not going to turn to violence, but non-aggressive way. Final aside on that one, also helps for negotiation. Negotiations go much better if you know what you want at the end, and also if you know what your bottom line is before you go in. Now, I'm just going to let 2 more people in. There we go. And share with you tip number 2. As I'm finding tip number 2, I'm going to attempt to answer John Clement's question, which is what if the person starts crying as a result of corrective feedback? I'll answer that as a coach rather than a barrister, because the barrister in me is a bit meaner than the coach. I don't think there's anything wrong with that, John, actually. If we all have emotions, we all need to get them out, I would say let them cry for a bit and then maybe resume the conversation at a later stage. I'm also a very big fan of reflective practice. So possibly there's a pause in and asking yourself, could you have done it differently? We're going to talk a little bit later about different settings, how you frame things and so on. So there might be something to learn there, but although it's awkward, I don't think it's the end of the world. Okay, tip number 2 is the simplest rule for persuasive advocacy, for trying to get what it is you want. Maybe flexible working. Tell them what you want, tell them why they should give it to you, and what's not written there is then stop talking. Don't talk them out of it. Don't go around in circles saying what you're probably thinking is, I won't be as productive, but don't do their job for them if their job is to object. Put your case. It's also, I think, a powerful tip for us to remember the importance of simplicity and evidence, both of which are fairly widely reaching principles for good communication, written and oral. Evidence is important because you don't get very far in this world with because I said so. If you're persuading somebody, you're probably going to have to think about why they should want to give it to you or what's in it for them. That usually involves evidence, possibly your own evidence. I'll come back to you in a month and show you how productive I've been, possibly external evidence, a study. You need to think about it though. You don't get things just because you want them, is I think a fairly tough life lesson. There's no automatic entitlement in a courtroom. In fact, most people, litigators, will give you various views of prospects of success throughout a case, 60, 70, 80%. They'll give you those prospects. Most of us would say once you walk into a courtroom, your prospects are no better than 50%. You have to earn what it is that you're after. So think about how to persuade them. What's in it for them? What's in it for the company? And if we just tie those two together, I've sort of used the expression flexible working thrown in there. That, I don't think, is specific enough for you to have as a purpose. I think you'd have to think about something like, what I want is, I'm not suggesting you phrase it like this, but what I want is 2 days in the office, 3 days at home, 40 hours over a 5-day working week, with the only core hours I need to comply with being 10 till 2. The rest being mine and being flexible. So we've gone from flexible working very vague. Better conditions, very vague. Higher pay, also quite vague. Move it to the specific. Be clear about your purpose. And then think about what evidence you can bring to that and support why they should give it to you. This study shows that people working from home are X% more effective. Or can we determine that we'll have a review of this in 2 months after a trial period? So what we're moving away from is accidental, natural emotion, moaning and whinging, towards something much more purposeful and planned. Okay, I'm glad to see that you're helping each other out in the chat as well. That's saving me a lot of time and effort. Good advice there, Alison. Thank you. So, tip 3. This is where I will need you to do some thinking about forum and timing. There was a study carried out in respect of 1,000 rulings by 8 judges. It was in Israel, but that might not matter too much. And they looked at the likelihood of a favourable ruling and how it related to time of day. How much more likely somebody was to be released on parole if you were the first one up, beginning of the day, after a nice breakfast, after a good night's sleep, as compared to the 10 minutes before lunchtime. You can see there that you're anywhere between 2 and 6 times as likely to be released if you are one of the first 3 prisoners considered versus the last 3 prisoners considered. The figures were declining in time, 65% to nearly 0 before the meal break, and spiking back up to 65% after a break for a drink or a snack. So timing matters. You can probably relate to snatching 5 minutes with your boss when they are trying to run out to lunch or get home for the weekend. Probably not as ideal as trying to make an appointment with them, finding them when they've got an hour spare and sitting down calmly to speak to them. It's not just timings though, it's thinking about how to do this well. How do you create a favourable environment to persuade the person that you want to persuade? I think back in the day when I was still a barrister rather than anybody dealing with coaching or communication or leadership, there was a school of thought that it was a bit Wall Streety, I suppose, that you should have important meetings in your office and people should come into you and they should have their back to the door. You should be behind your big grand desk. I think we can probably be a bit cleverer than that and probably be a bit less egotistical than that as well. Would they feel more comfortable if you went to them? Are you likely to get them to listen better, to be more responsive, possibly to not burst into tears if you go to them rather than insisting that they come to you? Sometimes, and there are lots of instances of this being successful, we can see that walking along or even driving side by side, driver and passenger, not side by side in different cars, can provide a really safe space because you haven't got constant eyeballing of each other. People can look around, taking the view, taking the fresh air. It might make them more relaxed and more receptive. Similarly, when you give a presentation, that thing that most people are afraid of, the studies would tell us, would it be easier if you sat down? It doesn't have to be a TED talk. You don't have to be pacing with a mobile mic. What would make it easier for you? Because people pick up on your nerves, your anxiety, what's making it hard for you. And that's, I always think that the audience at public speaking are a bit like dogs in that they can sense fear. And what they want to sense is both confidence and fun. And that's what you want to get across to them. So think about what works for them. Think about what works for you. I suppose on a slightly, I don't know, ostensibly more trivial matter, think about how you want to feel. Lipstick, maybe. Barristers wear wigs and gowns. I've got my very battered wig tin here today. Think about what it is that helps you perform best and what gives them confidence in you. Barristers take the wig thing so seriously, really, that they we sometimes call the newer members of the profession white wigs because they're not battered and dragged around the country like a more senior person's wig might be. So there can be something about presenting that confidence to people. And I think every year since I was called to the bar, every couple of years, that was 99, they do a consultation on whether we should keep wigs or not. And one of the reasons that that keeps being approved is that they give criminal barristers and criminal judges a form of disguise so that they are not as recognisable in the car park as they are in the courtroom. The other reason is because it gives a degree of gravitas to the proceedings. If you walk into that sort of courtroom, Crown Court, serious matters, there's a more serious atmosphere. I think the difficulty with some of the people I've worked with is they see people having successful negotiations, doing brilliant presentations, and they think it's all just natural, when in reality a lot of work is going into that, and they're thinking about what will make it work. They're thinking about, do I need any slides at all? Can I use a minimum amount of slides? Can I see my audience? And so on. Okay, I'm just looking at Tamsin's telling us there. Tamsin is somebody I do work with as well, so it's a timely comment, Tamsin. And she says she has an agreement with her colleague that he can be late for a meeting if the lateness means that he eats before we talk. I think we've had that discussion, and I think he's not quite as good at listening if he's hungry. So good knowledge and a good tactic. Okay, let's get to the Beatles. The tip is to know your audience and tailor your content. The Beatles, along with the Teletubbies, along with Linford Christie's Lunchbox, and recently, along with the bank Monzo, all have the distinction of being within the category of people or things that have caused judges to ask, who is that? Who are the Beatles? If we use an example with Paul Gascoigne, who, for the younger members of the room, was a very famous footballer and is no longer a famous footballer, but still appears in the popular press quite frequently. His example is interesting because I think counsel had thought about this. Counsel knew, counsel representing Paul Gascoigne was before a High Court judge, and they knew that it would be up to them to get across to this High Court judge who might be perceived to be elitist. I'll come back to that in a second. They needed to get across to him who Paul Gascoigne was. I think it was a case about his biography, or maybe it was a libel case. I think the biography was Linford Christie. So he opened, not by assuming that everybody would know who Paul Gascoigne is, he opened by saying, Mr. Gascoigne is a very well-known footballer. But the judge in that case, who had quite a reputation, it has to be said, replied, rugby or association football? So very clearly wanting, I think, to give the impression he'd never heard of Gaza. He later asked, isn't there an operetta called La Gaza Ladra? I don't know the answer to that. He's probably right about it, I suspect. So questions in themselves can be quite powerful, I suppose, is one thing. But I think the better message is, for this tip, how do you get your message across in language and terminology that the other people understand. You might not get it right first time. He's a very famous footballer, but you can expand on it once you ask the question, as long as you've thought about it, as long as you've thought about who it is that you're speaking to and what sort of level of understanding they are likely to have. If we think about written communication for a moment, I do quite a lot of training in the expert world on report writing. And one of the things we talk about a lot are abbreviations and jargon. One of my delegates said to me recently, abbreviations are elitist. I thought, God, not just High Court judges, abbreviations are elitist because they stop people understanding you. If you're an accountant or a building surveyor or a consultant orthopaedic surgeon and you're attempting to communicate with somebody who just has a law degree, then you need to explain those terms that you're using. So think about defining them within the report. Think about having a glossary. If you are addressing an audience, try and think about what they might and might not know. I said at the beginning, I started out thinking everybody knew what a barrister was. When I moved into the training world and started working with experts, I found that experts, even those putting forward reports in accordance with the civil procedure rules, often don't understand that distinction. So I explain it more now than I used to because I've learned as I go along. I should just, before I move on to the next slide, I should just mention also that I couldn't find really anything that approached confirmation of that Beatles story, the Who Are the Beatles, which is meant to have taken place at the height of their fame. It's meant to have given rise to an oft-quoted answer, which is they're a popular beat combo, my lord. Can't find any proof for it, but it's a great story that somebody could be sitting as a judge in that time and not know who the Beatles were. As a word of balance, I suppose, I should say that in my experience, judges are pretty switched on. They actually spend most of their working days being surrounded by the worst stuff that you could imagine, from kids being mistreated to horrendous assaults being committed on people and so on, to the absolutely widespread problems of addiction, that they really are immersed in it. They probably just do different things with their leisure time, I suspect. So just a little word of defence for them there. Okay. Now, this one and a few of the ones to follow are fairly rapid fire now, so that hopefully we should, not all of them, but some of them are, so that we should have some time for some questions. Do be ready for a grilling. I've said don't lead with objections unless there's a really good tactical reason to do so, but you absolutely need to be ready for them. Put on the slide there some of the things to think about. What would you ask? What's the objection likely to be? How can you put their fears to rest? I think also there's some merit in thinking about how you can be ready more generally for difficult conversations, because obviously not every difficult conversation you have will be a planned conversation. Sometimes it will be planned by somebody else, but they're coming up to you and saying, I'm not happy about X. I need you to fix Y. How do you then deal with those difficult conversations? And for me, just as you can think about how to prepare for a grilling, you can also, with some practice and some thoughts, find a blueprint or a toolkit for speaking well in difficult moments. And I will just share some of the tips that I actually got from a book called Failure to Communicate: How Conversations Go Wrong and What You Can Do to Right Them. And that's by somebody called Holly Weeks. And I've combined her suggestions with mine, which are thinking about, is there a theme for you? Do you immediately lose your temper? Does your voice go a bit shaky? That used to be one of mine. Do you go quite red here or here? That can be quite common. Do you forget your words? Repeat yourself? It's really worth reflecting on that, getting feedback from some other people, maybe doing some practice. And some parts of the toolkit that then help others, which might help you, are being clear and direct, dancing around, hedging around, not quite saying what you think, not quite saying what you mean, tend not to help, but tend to put that problem off for a different day. But what you need to do, if you're going to be clear and direct, is, and this is her phrasing, not mine, find temperate phrasing. So lots of barristers have stock phrases that they can turn to. If we have a witness who has done absolutely terribly, has fallen for every trick in the book, has completely destroyed their own case, what we would tend to say in closing is, Your Honour, I will concede from the outset that Mr. Smith was not a sophisticated witness. So I'm conveying in neutral tones, might not be that clever, and I would usually go on to say, but he's very honest, if I could. You might find some help in saying, thinking about saying, for example, I disagree with that, temperately, neutrally, rather than just falling back on what load of rubbish. I disagree with that. It's direct, doesn't dance around. You might not be able to go that far if you've been surprised, if you're having this spontaneous conversation. You might instead want to ask for time. I need to think about that. I don't know how I feel about that at the moment. And then I think a really important principle in all of this is you have to have the honesty and integrity to take the next step, to say, I'll get back to you on that tomorrow. Could we speak about this on Friday? So not all your temperate phrasing and neutral toning will be to put off, but sometimes there's nothing else you can do. Sometimes we do need adjournments and we have to work quite hard to get them. Other people won't always agree with you. That is just life. It's, I suppose what we're talking about here is both finding a way to persuade them when it's something you want or something you want on behalf of a team member, and also being able to respond to them when they're asking you for something that makes you feel, initially at least, a little bit uncomfortable. Okay. Then a bit about preparation. We always tell our pupil barristers to be the person in the room that knows most about the case. I think just using the expression pupil barristers might make you want to stop listening to me. So we're not known as a profession for being desperately up to date in either our terminology or our approach to business and so on. But there are some things we are good at. So we tell our pupils, you're going to be in there, you could be asked anything, representing somebody, you want to get the best possible result for them. You need to know more than anybody else about this case. And this ties in with what I said just a little bit earlier about some of this, I will admit, being hard work. If you think about the people you know who are great communicators, some of them might be naturally brilliant. Most of them are working harder than you think at that. I actually coached somebody in a firm in Manchester last year who said to me, oh, he's just brilliant. He just walks into these meetings. He just says everything. I just can't do it. I've got to cover all the bases because otherwise they might misunderstand me. We did quite a lot of work working through it together. I took a bit of a gamble and I said, ask him if that just comes naturally, or ask him if he's worked really hard on what he's going to say in that difficult meeting. And thankfully, his director said, yeah, I've worked really hard. I've prepped it, I've thought about it, I've thought about how to make it simple. even thought about how to appear natural. What I haven't done is just walked in and blagged it. So some of it's hard work, some of it's practice. One of my former colleagues, who's no longer with us sadly, who was the recorder of Manchester for a while, got quite a reputation in the press for being the sentencing judge when those riots happened a few years ago. He reputedly, I don't know if this is true or not, but he reputedly would write his cross-examinations, his questioning of witnesses that were hostile to his case, by writing question 1 and then thinking through all the possible question 2s, depending on what the answer to question 1 was. He would then write his question 3 by thinking about what all the possible answers to all the possible question 2s were. I can't imagine how he put all that paper together, because it will have been in the days before electronic whiteboards, I think. But that is how he did it, so that he was ready and he was prepared. And another word, I suppose, for reflection is that what you need to do really from now, but also looking backwards, is think about those conversations that have gone well, think about the ones that have gone badly, see if you can find that common theme and work on that. Okay, I feel like I've not been back to the chat for a while, so I'll just have a look at that. Oh, Lindsay, hi Lindsay. So what's the amount of time you think you can hold an audience attention span? Does it depend on the audience? Should you share delivery to mix it up? Yeah, I mean, I think that's a really good idea, Lindsay. We used to get laughed at as barristers, some probably still do, that our working day is 10 till 4. People used to say, what a DOS, could you not get to the golf course any earlier? How on earth does that work? It's not efficient, is it? Court of Appeal will continually come back to us and say, juries cannot concentrate for extended periods of time. So if you've got a jury, you're going to have your 10 till 4, you're going to have many breaks within it. Rather than having a lunch hour, we'll have an hour and 15 minutes. We'll have 1 till 2:15. Thanks very much. So I think there's some support for that there, Lindsay, that people do lose focus and attention. I mean, not always, you know, there are some brilliant speakers out there, aren't there? There are people you literally could listen to all day. But I think mixing it up can work really well. I think you've got to be really, really well prepared though. You don't want to be stepping on each other's toes. You don't want to be covering the same points. You want to make sure that the audience are getting something really quite powerful, impressive. And I think I would probably add an extra but to that. I think that works better if there's a purpose to it. So if one of you is particularly specialist in something, they could cover that, and somebody else comes in with a complementary topic or a complementary view on that type of thing. Okay. Great question. Thank you very much. Let's bring Bart Simpson into the game. Very little improves with repetition. This is where I think the bar moves away from your more traditional TED Talk coaches and so on. Because lots of people will tell you, no, you need to say everything 3 times. You need to tell them what you're going to tell them, then tell them what you've told them, that kind of thing. We would take, again, probably a slightly harsher view and say, if your message is clear, if you've thought, prepared, got some evidence, conveyed that message confidently, it only needs doing once. They will have heard you the first time. They might not have liked it, but you saying it a second or a third time might not help. It does, though, depend on the audience, like so much of this. Knowing them, having some insight into them. If it's a presentation, what are you trying to do? Are you trying to look like the cleverest solicitor in the room so they send you more cases? Or are you trying to show some personality? How do you achieve that? And I think the key theme for me on this slide really is it is your responsibility to make sure that people are understanding you and that you're understanding other people. So don't be afraid to ask questions. Mr. Justice Harman could have heard that whole trial assuming that Gazza was a rugby player. He asked the question instead. Don't be afraid to look silly. You look much sillier if you assume and you're wrong. So encourage that, embrace that. In a particularly difficult conversation, probably that somebody's approached you with a tricky problem type of conversation, good idea to repeat back to them what you've heard. So what I think you're saying to me is that you don't want to get on a train and you don't want to come into the office. That kind of thing. No, that's not what I'm saying. I'm not saying that at all. I will get on a train, but only 2 days a week. So you're checking that you're properly understanding so you don't both just go off down a very difficult path. Okay, and now we get to a very discreet tip. Know when to stop. This is when we get to bring our emoji in. I got told by somebody who went on to become a judge this tip in, I think, the first week I was in chambers. If you have a fabulous point, this is the winning point. This is what gets my client home, gets my client out of prison even, although I didn't do that kind of work. But it gets my client to save lots of money, win lots of money. What I shouldn't then do is dilute that brilliant point, make them lose their appetite for that brilliant point by serving it up alongside rubbish points. Poo emoji there, standing in for rubbish points. If you know your good point, think also about where you put it. Do you open with it? Do you end with it? It might be that you have to say more than just one thing. Maybe it is a presentation. But what we're talking about here is trying to keep high quality throughout, making the dip in the middle between your brilliant points minimal rather than a huge pothole. Did lots of pothole cases. Such was my very glamorous practice. So, work on your listening. We've talked a lot about what to say. It doesn't get you anywhere if you don't listen. Many, many people are waiting to speak rather than listening. Communication has an audience, otherwise you are just speaking into a void. If you ignore the audience, if you don't listen to them, you don't notice them shuffling their feet or whatever it may be, or yawning. I can't see anybody's face now, so you could all be yawning, but in general, in the pre-COVID and the post-COVID world, keep an eye on them and really listen to them. Those of you who are already connected with me on LinkedIn will have seen me being very giddy over summer because I got to ask a question to Tim Peake, Major Tim Peake, who was our British astronaut on the International Space Station, and he was at a conference being run by a company I do some work with. And I asked him about what he thought, having been in a life or death situation with a multicultural, multilingual team, where if things go wrong, there are really serious consequences. I asked him what his top tip for communication was. Didn't prompt him, didn't tell him I was going to use that in newsletters forevermore and presentations forevermore, and his answer was to listen. And he assured me that when he went through his training, that was what they worked on. You go in thinking, I've got the best idea, I know what's right. You miss out on the opinions of those other people, and they could be much, much better. So I think I've covered most of my spoilers. We've looked at them for Christie's lunchbox, which the judge didn't understand. We've looked at the poo emoji. Where does the taxi fit in? Hopefully it fits in with tip number 10, which is about being brave. Another thing I thought everybody knew is what we at the bar call the cab rank rule. I am not sharing that, am I? I'm just talking to you. So the cab rank rule is taken from the licensing system used for Hackney cabs. It's the rule that says if the black cab has its light on, if you flag it down, if you have enough money, it has to take you to where you want to go. I'm desperately working behind the scenes here to show you a picture of a taxi cab, but you know what they are. We adopt that. There's a heading in our code of conduct that says cab rank rule for barristers, which means that if you instruct me to represent you, if you pay me properly, if I'm competent to do it, if my diary is free for me to do it, I can't say no. So if you've ever wondered how people accused of murder, rape, paedophilia, terrorism get barristers to stand up and defend them, that is the most common question we're asked in taxis, incidentally. How do you defend those guilty people? The answer is A, they're not guilty yet, they're accused, and B, because we have to. And the thinking is, if we don't have this principle, we pass all the power down to the next level, which might work sometimes, might not be brilliant. The reason I've put it here is because there's another misconception that barristers are somehow more senior than solicitors. People always say to us, oh God, especially me, because I've left, they'll say, oh God, you put all those years in to get there. I say, no, it's less years, fewer years, I should say. Because to be a barrister, you do the same qualifying degree, you do a vocational year, solicitors and barristers do that too. Then you do your on-the-job training, and barristers is half the time that solicitors have to do. So even if you're not a child genius, even if you go to uni at 18 rather than any earlier, you can still be a barrister by, what does that make it? Practicing by 22 and a half, 23. And you have to stand up and represent clients. There are some rules around that, I should say. Stand up and represent clients. Whatever you think of their case, you have to be brave. But my message to you would be, if that 22-year-old in a fancy dress, in a wig, can do it, you can do it too. And often the way to do it, the reason I put fun on that slide as well, is to switch how you think about it. If you dread a presentation, if you think, God, I'm rubbish at them, I hate them, it's going to be a massive drag on your week. If you think, wow, on Thursday, I get to speak to 50 people about something I'm really passionate about, I wonder if I could get them to learn a couple of things. I wonder if I could generate a debate and get some ideas. You're then in a different zone. The dogs who sense the fear won't have anything to sense. They'll sense that it's fun instead. So there's a little bit of reframing in there as well. I think the other thing to remember about bravery is that silence also has a consequence. If you just shut up, you don't ask for your flexible working, you don't object to that unfair system that's been introduced in your work, you're stuck. You could go and find another job. That's a bit extreme. Wouldn't it be better to be a bit braver? If you stop now and try to remember what it was that you were worried about last September, I guarantee you'd struggle. Some people find it really helpful to ask themselves, how important is this? Will it matter in 10 minutes? If not, you probably don't need to bother. 10 days? Might be able to live with that. 10 weeks, 10 months? Probably needs tackling, but probably any discomfort you experience, tears, shouting, not from you, obviously, but other people, that will disappear. You won't have the terrible consequences that you are imagining. I can almost guarantee that. Bravery can get you far. It's I know that we are much more aware now about things like anxiety. I am totally on board with us all being a bit kinder to each other in that sense. But you also get real benefits from being brave if you can. So I would urge that upon you. I'm conscious we've only got a few minutes left. I've only got 2 slides on written evidence. I've mentioned some things along the way, so I'll just share those with you. I do train in report writing. That's a long 7.5 hours on Zoom, I can assure you, but it works. Here are my top 3. Have a structure. Don't write into a void either. Have your reader in mind. Make it easy for them to read and understand your work. And do reread it before you submit it. It's very tempting to press send. It's taken enough of your life. You've stopped seeing what it says anyway, probably. But if you can, leave it, walk away, have a cup of tea, go overnight if you can, come back and read it properly. There's a great quote which the internet widely attributes to Mark Twain. I don't know if it's Mark Twain or not, but it's said that he writes a very long letter to a friend, and at the end of it he says, "I'm sorry I had to write you such a long letter. I didn't have time to write you a shorter one." It takes longer to edit yourself, but it improves quality. And a lot of what I'm doing with experts will apply to you in your own professions as well. If you're writing something, it's a bit of a calling card, isn't it? It's a bit of an advert for how good you are at what you do. Take the extra time to edit it. It's not the case often, but longer is better. Final slide on writing. I think as lawyers, we're often astonished at what people will put into emails. They can and will be used in evidence. There will often be an obligation to disclose emails. So although they feel like a very quick, very informal way of communicating, they have hazards. Be careful, but also dance like nobody's watching. And then finally, I did want to just tell you, bonus tip, I didn't know where to fit it in otherwise. Another thing that comes in our code of conduct is to be fearless but courteous. Being confident, being assertive doesn't mean you have to leave your manners behind. In fact, actually, you'll find in many of our courtrooms there is a politeness that is almost so false that it seems insulting. We don't get to do that stuff they do on The Good Wife and Suits and slam books down and say objection. Instead, we sort of half stand up and we say, Your Honour, I'm sure it was unintentional, but I do think my learned friend has misled the witness. We're overly polite. And I'm not suggesting be overly polite, but I would say that being polite does get results often. That is all I want to say to you. It's 12:57. I'm going to just look at Alex's question, but if you have to run, I understand. If you have a question, feel free to unmute yourself and show yourself as well, just so you don't all speak at once. Alex, move, contribute, and participate can ensure they learn the material more. It feels a bit salesy and forced in this area. Do you mean your area, Alex? Finance? There is, I think, a truth that people will learn and absorb more if they're involved. If you can give them a little thing to think about, if you can maybe get them to jot down some answers. I have to say, you'll have gathered in this hour that the bar is quite old school. If I turn up at a presentation and somebody tells me, all of today is going to be group work and you're going to play with this pack of cards, I want to crawl under the table, but I've got better at it, and I would concede that often it does work. It does work if you are getting people a bit more involved. Makes them remember it a bit more, maybe. I think, those of us who work in this field, but if I do a workshop in this in real life, we can very easily do 3 hours because we'll put some coaching, we'll put some exercises into it. If we're doing this, it's a little bit harder to go for more than an hour, to go back to Lindsay's question as well. Tamsin wants to avoid being defensive on the receiving end of feedback, even if it's constructive. There's a little bit of faking it till you make it there. I think the best tip, I was talking to somebody about this the other day, that I was in a very bad habit for many years of, if somebody would say to me, oh, I like your top, I was constantly say, oh, this old thing, it's just from Sainsbury's. That kind of stuff. And somebody said to me, what you should do is just say thank you. And I think saying the thank you, I think that answer earlier, sorry, I've forgotten whose answer it was, but that answer about letting people calm down can apply to you as well. So say thank you, go away, think about it and digest it. And then if you need to, you can resume the conversation with a bit more prep and maybe a bit less emotion. Sometimes emotion's good, but maybe a bit less emotion at that stage. Thank you. A question about politeness. Yeah, you don't want to look like you're being subservient in court, unless you're doing it tactically. It's interesting that, isn't it? And I read a lot around this, and there are some people, particularly Americans, who when they talk around this topic, particularly feedback, they will say things like, what you should do is ask for permission first. Can I give you some feedback? I was once behind a lady in Brooklyn at a croissant stall, back when we could travel, and she said to her 5-year-old, can I at least buy you a croissant? And then you can eat it if you want to. And I thought, oh gosh, that's going to end badly. So I think you've got to be careful, Ferouz, not to put yourself in a position you don't want to be, and don't ask for permission if you don't need it. For example, do try and think about those boundaries. I think though, if they think you're subservient and you're not, you're bright and you're on an equal footing, you might even be giving yourself a tactical advantage. Hope that answers that question. I see lots of people going back to their afternoon's work now. We'll probably have to draw it to a halt. I think Sean is going to send the slides out this afternoon. Do feel free to connect on LinkedIn, put lots of tips on there sporadically. I send newsletters sporadically. Do feel free to connect. Let me know how you get on. Thank you very much. Oh, good, Sean. Do you want to say anything else?
Yeah, just really quickly, just to say thank you very much, Kath, for your time this afternoon and for hosting this event, and thank you to all of you for attending. And yeah, as Kath says, I will send out a post-event comms shortly with lots of extra info in there. So I will see you all next time. I
have noticed, Sean, somebody's just entered the waiting room. I think they might think it's at 1 o'clock. I won't let them in just now when 40 people are looking at them. Yeah, maybe I'll end the meeting and I'm sure they'll get in touch with you, Sean, won't they? So
yeah, no worries.
Yeah, we'll do it that way.
They can watch the recording.
They can. Thanks very much, everybody. Good luck.
Thanks, everyone.